Good morning and welcome everyone to today's webinar, Increasing Accountability for Conflict-Related Sexual Violence, hosted by SIPA's Institute of Global Politics, IGP. My name is Karen Yarhimilo. I am the Dean of the School of International Public Affairs and an Adlai E. Stevenson Professor of International Relations. It is a pleasure to welcome you to this important convening. First, let me begin by thanking Sheryl Sandberg, Jen Klein, Rachel Vogelstein for bringing us together around such a critical issue. Conflict-related sexual violence is not a tragic byproduct of war. It is a deliberate tactic. And as we know from the political science literature on civil wars, sexual violence is used strategically by armed groups. But as the literature confirms, conflict-related sexual violence is not an inevitable feature of all wars. At a time when the world is seeing an alarming rise in violent conflict from Ukraine to Sudan to Gaza, the need to strengthen accountability for these heinous crimes and hold perpetrators accountable have never been greater. And this is why today's discussion further the important work that we're doing at SIPA at the Women's Initiative, which has made conflict-related sexual violence one of its policy priorities. And today we're building on our February 2024 event on preventing and addressing conflict-related sexual violence. So today, this virtual roundtable series will bring together scholars, practitioners, and civil society leaders to discuss increasing accountability and supporting survivors of conflict. And this is why this is exactly the kind of engagement we envision when we set up IGP and the Women's Initiative. We want to convene timely conversations on pressing global challenges so we can advance innovative policy solutions that we deeply, urgently needing. We hope that this webinar will contribute to the collective strategies that advance justice, accountability, and security for all. I want to really thank you all for joining us. I look forward to the discussion ahead. I think it will be a really meaningful one. And it is my pleasure to turn it over to Sheryl Sandberg to start this conversation. Thank you, everyone.
Thank you all for being here today. I want to begin by recognizing the really extraordinary people who make this possible. Karen, your leadership is unprecedented, your focus on these unbelievably important issues. Jen Klein and Rachel Vogelstein, who bring such invaluable experience and dedication to this work. And Professor Jean-Marie Guénaud from the Kent Global Leadership Program on Conflict Resolution for sponsoring this roundtable series. As Karen said, the use of sexual violence as a weapon is deliberate, and it's one of the most devastating realities of war and conflict. And unfortunately, it's on the rise. Conflict-related sexual violence increased by 25% last year compared to the previous year, and women and girls are 92% of the victims. And while the numbers are so staggering, each one of these represents a woman or girl, or a man or a boy who endured one of the worst things a human being can experience. It's important to realize that almost none of these crimes will ever be reported because survivors are sometimes killed, victims are sometimes killed, and so many survivors are silenced by stigma, shame, fear of retaliation. But even when survivors overcome all of that and do come forward, the challenges in evidence collection make convictions very difficult, and people are not always prosecuted, and they're not always trying to be prosecuted. So for most survivors, the harm doesn't end with the assault. It continues when the world looks away instead of delivering justice. And that's why conversations like this are so important. We're here to talk about the new ways to hold perpetrators of CRSV accountable, from stronger sanctions to universal jurisdiction to the possibility of a Crimes Against Humanity treaty. because survivors deserve nothing less. And it's an honor to be joined by such extraordinary leaders in this fight. And I apologize in advance, I'm terrible at pronouncing names. Oleksandra Matviichuk, a Nobel Peace Prize winning human rights lawyer and head of Ukraine's Center for Civil Liberties. Beth Van Schaack, former US Ambassador at Large for Global Criminal Justice, who has worked tirelessly to bring global criminals to justice. Margot Wallstrom, the first ever special representative of the Secretary General on conflict-related sexual violence. Thank you to all three of you for being here today and for your voices and for your leadership.
Thank you, Cheryl, for framing our discussion today and for your leadership on the issue of conflict-related sexual violence. We're so grateful. I also want to thank Dean Karen Yarimilo for her partnership on this critical issue. My name is Rachel Vogelstein. I'm a professor at Columbia School of International and Public Affairs and director of the Women's Initiative at the Institute of Global Politics. And along with Cheryl, I'm very pleased to welcome our panelists to this conversation on increasing accountability for conflict-related sexual violence. I'd like to begin by discussing strong accountability measures for this crime. And Margot, let's start with you. You were appointed as the first ever special representative on sexual violence and conflict, which was a major step forward at the time for international recognition of this issue. And yet we know that impunity for these crimes persists from the DRC to Syria and beyond. Survivors of sexual violence and conflict rarely see justice. So tell us, what are the primary obstacles to ending this impunity at both the international and the national levels?
Thank you very much for inviting me, and thank you, Rachel, and all of you to organize this. Yes, of course, to fight impunity was one of our main priorities when I took office, and this is now 15 years ago. And I was the first one nominated as a special representative on conflict-related sexual violence. And of course, it was a matter of keeping this, putting it and keeping it on the Security Council's agenda, to define it as also a threat against peace and security. But fighting impunity surely was one of the first things that we discussed. And let us just remember what the situation looks like now. And I had to make sure that I read up and get the proper numbers. In the course of last year, more than 4,600 cases of conflict-related sexual violence, including as a tactic of war, torture, terror, and political repression, were documented. And as we heard from Sheryl Sandberg, this was a staggering 25% increase from the year before. Now, why is this still met with impunity? I would say because of women's participation, or rather the lack of women's participation, and also the chain of the necessary chain of services and mechanisms that starts with the survivors. If a survivor feels that she's actually the one who carries the shame and the stigma of this, she might not report it. I remember that we often quoted the woman who said, if the bleeding had stopped, I would never have sought help. So that's what it took. And this is still the case in many parts of the world, that it is the victims or the survivors that carry the shame. They feel it was their fault. They cannot see before them that there is a chance that they will get any help, that they will get reparations, that it is worth it to go through such a procedure. So it is also considered a lesser crime. And in some of the trials that have been on conflict-related sexual violence, that has also been used as a defense. A soldier or commander said, "But I could have killed her." As if this is a lesser crime that should just be sort of condoned, forgotten about. And as long as women do not participate in any of the peace negotiations, in any mediation processes, of course, this will not be put on the table as an element in a new peace deal, be mentioned, be looked at properly, and also that there is a chance of this being dealt with. And this is still not the case. We cannot be sure that women will be around the table when peace negotiations happen in all the wars and conflicts that go on today. And we saw it in Tigray, for example. No women around the table there. And we know that sexual violence was part of the reality in that conflict and in that situation. So this is definitely a part of the explanation why impunity still reigns. And then you have all the other reasons. You have to make sure that the laws are there so that we have a legal framework, a normative framework in place. We have to make sure that the police and others who deal with it can collect evidence, that we can have a proper process going, and still too much is missing also in that whole chain of mechanisms necessary to fight impunity. So this is still part of the task in front of us. And of course, the office will continue to work very hard on that, and to make sure that all the naming and shaming is being done. And this year's report from the office, and I will finish with that, lists 63 parties now credibly suspected of committing or being responsible for patterns of sexual violence in situations of conflict on the Security Council's agenda. And there are new listings in the DRC, in Libya, the occupied Palestinian territory, etc., etc. So this is progress, and we made progress. We established these kind of lists, and we managed to get the mechanisms in place. We've trained peacekeepers and lawyers, and there are specialized police, etc. But there is too little being done in making sure that women's voices, survivors' voices, are being heard, and that their needs are being met.
So many gaps still in the landscape. Beth, I'd like to pull you in to talk about the legal framework that underpins this crime. Earlier in your career, before you served as U.S. Ambassador for Global Criminal Justice, you served in the Office of the Prosecutor under the International Criminal Tribunal for Rwanda, as well as the International Criminal Tribunal for the former Yugoslavia. Both entities were groundbreaking in establishing accountability for conflict-related sexual violence as a legal matter. So what lessons from those prosecutions remain most relevant today when we think about the landscape of impunity that Margot just outlined? And where do you think the international system has fallen short since those historic prosecutions?
Thank you so much. It's really an honor to be a part of this conversation that could not be more timely or important. Indeed, those tribunals, as you mentioned, were really groundbreaking in developing gender justice jurisprudence. While conflict-related sexual violence was rampant during World War II, the Nuremberg and Tokyo tribunals' juridical record was almost silent on these offenses, largely only referencing them somewhat euphemistically. And even the famous rape of Nanking does not receive the attention it deserved in the Tokyo proceedings. And as you mentioned, early in my career, I served under Chief Prosecutor Louise Arbour, who was a brilliant Canadian jurist who headed the Office of the Prosecutor of those two tribunals. She was intensely dedicated to investigating and prosecuting those crimes. Most importantly, she appointed the brilliant and indomitable Patty Sellers to actively develop a gender justice docket with respect to both Yugoslavia and Rwanda. She was willing to expend investigatory resources to search for and to develop evidence and to work carefully with victims, survivors, their families, their communities in a trauma-informed way, although that language was only just being developed at the time. She was really groundbreaking in insisting that we work carefully in these communities in order to fully develop an evidentiary record. She also made sure that indictments that she was seeking and that she filed included CRSV charges against not only the direct perpetrator, but also against their superiors, who can be held liable under principles of command responsibility. And a result of all of her upstream efforts in terms of creating an office that was dedicated, setting expectations for including this work in her indictments, etc., the tribunals then were presented with facts and evidence and were able to issue really groundbreaking jurisprudence, demonstrating that sexual violence can be successfully charged and prosecuted as war crimes, crimes against humanity, and genocide. So a few key examples. The Yugoslavia Tribunal issued a really important judgment stating that various forms of sexual violence, rape, etc., could also be charged as torture, which would open the door for states to prosecute rape and sexual violence under their national torture statutes. In the Akayesu case, rape was charged as a predicate act of genocide, namely non-death genocide, causing serious bodily or mental harm to members of the group, which is baked into the Genocide Convention. In addition, superiors were charged there for gender-based crimes committed by their subordinates, including a woman who was found guilty of rape of another woman that was committed by her subordinates in her presence and at her direction. The work of the two ad hoc tribunals where I worked then laid the groundwork and inspired subsequent hybrid tribunals, so the Special Court for Sierra Leone and the Permanent International Criminal Court. So the Special Court for Sierra Leone, for example, identified the crime of forced marriage as separately chargeable from sexual slavery because, as they noted, it involves the forcible imposition of a conjugal status on a woman against her wishes that was separate and apart from forced sexual activity. The extraordinary chambers in the courts of Cambodia then built on this with respect to the forced marriage imposed upon individuals by the Khmer Rouge to say that men could also be victims of this offense, which of course was obvious, but just wasn't presented by the fact patterns in Sierra Leone. All of this jurisprudence was then codified within the statute of the ICC, thus laying the groundwork for the cases that the ICC has been developing. So Dominic Ongwen was recently found guilty of 19 counts of sexual and gender-based crimes, and we've just now, this last week, had a proceeding in absentia against his superior, Joseph Kony, or Joseph Coyne, who also stands accused of allowing sexual violence to happen and also participating in it himself. And Ntaganda, who was the former leader of the M23 rebel group in the Democratic Republic of Congo, was found guilty of in-group harm. So normally when we have charged war crimes in the past, it always involves harms to the civilians or to prisoners of war of the opponent's group. And with the Ntaganda case, the tribunal, the ICC, confirmed that in-group harm, so when women who are members of an armed group are raped by their confederates, that can be charged as war crimes or even potentially crimes against humanity. Now, we did have a setback recently in the Al Hassan case in Mali. There, the trial chamber of the ICC acquitted the defendant of gender persecution, but found him guilty of religious persecution, even though these two sets of allegations were inextricably intertwined. And I have to say the reasoning is quite baffling. It evinces a real misunderstanding of the situation on the ground and the definitive role that gender ideology plays in the violence of Islamic terrorist organizations, like Ansar Din, his group, or Hamas, as we've seen in Gaza. Most importantly, and I'll end here in terms of developments, in Afghanistan, we've had arrest warrants issued and sought against two Taliban figures, not only for their systemic program of gender persecution against women and girls, but also against individuals who do not conform to the Taliban's gender ideology and against allies of all of those victims. So it's a really groundbreaking development and the first of its kind to center violence on the basis of sexual orientation and gender identity. And it offers an opportunity to repair the flawed reasoning in the Al Hassan case in Mali. All of this international jurisprudence can inform national processes. So when we're looking at gaps in the chain, as Margot described, the law is not one of them. There's plenty of good law and plenty of good jurisprudence that courts, prosecutors, and investigators can rely upon. What we're often missing is a body of evidence and that real commitment that Louise Arbour demonstrated to make gender justice a priority.
That is a really helpful overview, Beth. Thank you, of the international jurisprudence on this issue. And it raises the question about how to translate that framework at the national level. Oleksandra, I want to turn to you. You've done significant work to recognize and preserve the testimony of survivors of sexual violence in Ukraine during the current conflict. And based on your experience supporting survivors and documenting violations on the ground, which national accountability mechanisms do you think are working well in Ukraine, and what do you think is still needed to improve accountability there?
Thank you for providing me a floor. I'm documenting war crimes in this war which Russia has launched against Ukraine, and sexual violence, unfortunately, is very widespread. But regardless this fact, it still become the most hidden crime. Office of General Prosecutor opened more than 180,000 criminal proceedings, but among them we have only 400 recorded cases related to sexual violence committed during this conflict, which is not appropriate for sure. So there were changes made on the level of legislation and practice to improve the situation. Last year, the Rome Statute was adopted, and because of that, some changes were made in Criminal Code of Ukraine, but it's still not appropriate to the international humanitarian and international criminal law. So, for example, my organization are involved in efforts to change National Criminal Court to complete this harmonization, which provide more effective tools for legal enforcement bodies and judges to provide justice in these cases. When we speak about practice, in the first year of large-scale war, the department devoted to conflict-related sexual violence was created in September 2022. Then later, it was created a victim support center, which was also very important and provide assistance to victims, not just of sexual violence, but other crimes committed during this war. There are a lot of trainings for prosecutors, for judges, according this topic, but still we see how the general system of criminal justice need to learn more how to put survivors of sexual violence in the center, to respect the dignity of survivors, and to look to people not just as a source of evidence. And still we have a lot of problems with lengthy consideration of cases, postponement of hearing without timely notification of victims, and so on and so forth. And one of the major problem which we face is the lack of access of absolutely majority of accused people, and which turns the even existing proceedings in proceedings of absentia.
An incredibly helpful look at some of the progress, but also some of the gaps in Ukraine. I want to move us on to talk about the assertion of universal jurisdiction, which is one way to address international crimes like conflict-related sexual violence, especially where filing a case in the International Criminal Court can be challenging due to limits or delays or other political obstacles. Beth, I'd like to turn back to you, given your prior experience serving in the Biden administration as the U.S. Ambassador at Large for Global Criminal Justice. What do you think are the advantages and the disadvantages of employing universal jurisdiction to prosecute conflict-related sexual violence? Is this a tool that should be used more often? Beth, you're on mute.
Notwithstanding the important role that the international tribunals has played in developing gender jurisprudence, inevitably it's going to be national courts, as described by Oleksandra, that are going to be the real engines of accountability for conflict-related sexual violence. The tribunals have helped to develop the jurisprudence, the methodology, and the law, but this now needs to be taken up by national courts. the principle of universal jurisdiction, which Cheryl mentioned, is going to be a really important tool in this regard. So ordinarily, states exercise jurisdiction on the basis of territory. They can prosecute crimes that are committed on their territory or by their nationals, and sometimes against their nationals. What universal jurisdiction does is essentially deputize all states of the world to empower them to prosecute international crimes, regardless of the nationality of the perpetrator or the victim, and regardless of the location of where that crime was committed. The theory is that these are crimes against all of humanity, and so all of humanity should play a role in making sure that they're appropriately prosecuted so that you can lay the groundwork for real and credible deterrence going forward. So leaders will think twice before they order their subordinates or allow their subordinates to commit sexual violence as part of a campaign of violence against an opponent community. So what we've seen is a number of states, as part of ratifying the ICC statute, which, as Oleksandra noted, Ukraine has recently done, incorporating those legal prohibitions into their national codes. And they often will do this in a way that extends extraterritorial jurisdiction over those offenses. Sometimes this is a function of their treaty obligations. So, for example, the Geneva Conventions require states to not only prosecute cases, but to seek out perpetrators and advance accountability for grave breaches of those treaties. They do that by virtue of treaty law, or now customary international law is essentially permissive. It says basically that all states have the right to exercise criminal jurisdiction over international crimes, war crimes, genocide, crimes against humanity. So we need to see more of this. We are seeing many states taking up cases. It started very much in Europe with respect to the overlapping conflicts in Syria and Iraq, but we've also seen it with respect to other conflict zones around the world. I'm going to focus on Germany because they've really been at the forefront in this regard in utilizing their universal jurisdiction laws and empowering their system to bring these cases. One of the first cases, however, was a bit of an object lesson, frankly. It didn't go particularly well. There were CRSV charges brought against two members of the FDLR, which was the sort of remnants of the Hutu power movement from the Rwandan genocide, who were operating in neighboring DRC and still engaged in violence against Tutsi communities. The victims, the survivors, were able to testify anonymously, which was positive, and their testimony was beamed in via video conference because they were very concerned about retaliation. However, the judge gave lesser weight to their testimony as a result of this. There was also, it was quite time consuming. There was the need to use interpreters. There was a lot of confusion about the trial processes. The victims and witnesses clearly had not been properly prepped in order to participate in this proceeding. And as a result, the charges were ultimately pulled with respect to some of the incidents that had been alleged in the earlier indictments. And the judge was concerned that the proceedings were going to take too long in order to get through all of the incidents that had been alleged. Ultimately, the individuals were found guilty, but much of the charges were dropped, and it was clearly not a positive experience of justice for those survivors and those victims. The problems associated with this case led to significant reforms within the German code, and for this, Germany is to be commended. They created, for example, an all-female investigator team. They enhanced their training around gender-sensitive and trauma-informed approaches to investigating CRSV. And they've also been creating these so-called structural investigations, which allow them to investigate an entire crime base with an eye towards later focusing in on individual perpetrators. And a key structural investigation that remains ongoing is that against the Islamic State for crimes committed since August 2014, in particular against the Yazidi. We know that the Yazidi were subjected to a genocide and that gender-based violence was very much undergirded their entire campaign to eliminate the Yazidi group within Iraq. This included sexual slavery, forced marriage, other forms of sexual violence and gender-based violence. A number of investigations have now moved forward against particular individuals, some that have included allegations of gender-based violence and some that inexplicably have not included such allegations. We don't always have a window into why these charges have fallen away or not been promoted, but we know that it takes work to develop witnesses and testimony, and these prosecutorial units need to expend the energy and the time and to bring experts on board who are well-versed in engaging in trauma-informed investigations. There's also a similar structural investigation involving harm within Syria, where we know that sexual violence against men in detention situations was also quite rampant. And so as those cases emerge, I'm really hopeful that we'll see some of them, including charges for conflict-related sexual violence, particularly when it comes to male victims, which we have not developed strong jurisprudence in that regard. But we know that that type of sexual violence can be rampant in conflict situations, especially in custodial situations, as we've seen in Ukraine, in Israel, and in Syria.
So, Beth, you talked about national implementation as well as international treaty obligations. And Oleksandra, I'd like to turn back to you. I know you've advocated for stronger international mechanisms to address conflict-related sexual violence. I want to inquire about one potential avenue, which is the UN Crimes Against Humanity Treaty. As negotiations for that treaty begin to get underway early next year, some are pushing for new provisions to strengthen accountability, including for this crime for conflict-related sexual violence. What do you think are the opportunities to improve accountability under this treaty framework? And what are the risks? How might the Crimes Against Humanity Treaty reshape international accountability on this issue going forward?
In the draft of UN Crimes Against Humanity Treaty, we see provisions which have already qualified sexual violence as a form of crimes against humanity. And because we know that crimes against humanity can be committed during the armed conflict, it's also relevant, will be relevant to situation in Ukraine. Just recently, the International Independent Commission on Inquiry on Ukraine, which was created by UN Human Rights Council, issued a report, and they analyzed the legal practice of abduction, torture, sexual violence, and killing civilians in the occupied territories, and they named this as a crimes against humanity. The same conclusion was made by OSCE Moscow mechanism. So I hope that when this UN Crimes Against Humanity Treaty will be adopted, it will strengthen the level of international standards and provide more support for survivors of sexual violence. I also want to draw your attention to another legal instrument, Ljubljana-Haška Convention, which provides obligation for states to cooperate when the investigation is going on against war crimes or crimes against humanity. And because it's not a UN convention, it's easier to expect that it will come into force more quickly. And that's why it's so important that as more as possible states will join to this new legal instrument.
Both of those are important processes to keep our eyes on as we think about increasing accountability for this crime. I'm mindful of Beth's suggestion earlier that much of what is needed by way of legal frameworks currently exists, notwithstanding the importance of strengthening that body in the ways, Oleksandra, you just talked about. And so I'm wondering, beyond special tribunals or new treaty obligations, what other accountability mechanisms, such as hybrid courts or special investigative bodies or other survivor-centered approaches, could help advance justice here and translate some of the broad international obligations into accountability and practice? Margot, any thoughts on what's needed to make this leap from the words on the page in terms of the law that exists and what we're seeing in practice?
Thank you, Rachel, and thanks to Beth and Oleksandra, because they have given a brilliant overview of how this has been developing over the years since I was there on the post of being a special representative. But also, I think showing that you have to have that sort of survivor-centered approach all the time, to remember where it starts, and to get them to any survivor to report, to make sure that there are, for example, police or the justice system is working the whole way, because some of these procedures also take a very long time. And I think that many of the survivors feel that this is very painful and excruciating to an excruciating weight for them most of the time. And I think also we have to complement, as we've heard already, with training judges, training all of the different professions involved in all of this. But we also have to make sure that there are resources set aside. And we are in a point in time when, you know, more money is spent on buying new weapons to fight these wars. And for one day, they spend as much as what is used for a whole year on these services for the survivors. And this is also being reduced. So it's really a kind of competing priorities here if we look at this issue. And may I also mention that, and this is of course something that both national governments and United Nations also has to look at, you know, what can we do? And member states have to look at what can we do to ensure that there are more money set aside for this. And of course we had, when I started also, we had a team of legal experts connected to our office, and I must say that they have done also a wonderful job. And what we've heard now is just another proof of the need for such experts that can also help in looking at these cases. They went to Sierra Leone. They've been working with a number of countries to make sure that these cases are not forgotten, but actually dealt with. So that's what I think is missing right now. This kind of resources necessary to make sure that the whole chain works.
So, Margot, you talked about the naming and shaming and investigative tools that the Office of the Special Representative on Sexual Violence and Conflict at the UN has. We heard, Beth, from you about the international legal framework, and Oleksandra, you talked about the national framework in Ukraine. I'd like to talk now about sanctions as another accountability measure. And Margot, turn back to you. During your tenure at the Security Council, sanctions were one of the tools in your policy toolbox, including the first ever standalone criterion to sanctions individuals based on their involvement in planning, directing, or committing acts involving sexual and gender-based violence. But there are critics of employing sanctions as an accountability tool who argue that they too often fail to actually reach perpetrators. Do you think that sanctions are effective to impose accountability for conflict-related sexual violence?
I think prison cells are working better in many cases. We want to see more of these perpetrators in prison cells, but this is important that we have a whole toolbox with both sanctions and other types of punishment also as a deterrence. And of course, we started with making sure that there were these listings happening, and the whole idea is that there must be a coherence between the list of parties in the annex to the annual report, the perpetrators, and the designation also of sanction regimes for both targeted and graduated measures. I think this is sometimes not working perfect, but I remember that we discussed things like, what if you could find sanctions that reach those guys that were these criminals that bought cattle or big houses or big jeeps or what have you? What if we could stop them from doing that and enriching themselves in a particular area where they worked as some kind of SARS, and including doing sort of rapes and sexual violence, using sexual violence as a weapon or a tactic of their warfare. And this is, of course, not easy to do, but I think that there is an ongoing discussion, of course, about sanctions, and they are one of the tools in the toolbox. And I think a lot has happened here, and I think that this has been used. I mean, there are a number of these joint communiques that the Office of the Special Representative of Sexual Violence has been using to make sure that this is recognized and pointed out, and that they agree on the kind of legal system that should be used in a particular country, and also sanctions regimes. But it is sometimes a very blunt weapon in these cases. And again, I think there must be much more focus on making sure that these survivors can get the help that they need, because this is also, it affects the whole chain, also the chain of justice. And can I also say to Oleksandra, I think that Ukraine actually these days, you have such a leadership role, both on a matter like ecocide that I know fairly well since I've been working on a report on that, but also on these matters, because it's also a matter of using modern technology to collect evidence, to make sure that you can use the whole legal system by also providing evidence and, as I said, the help to the survivors. So I'm not a lawyer, so you are better, or a legal expert, so you are better at describing all of these mechanisms as they work today. But I think it has been painful to see that some of the processes have taken so many years that, in the end, also the victims or the survivors feel that they have been on display or show people for show.
That's a critical reflection on the efficacy of some of these measures. The time that it takes to pursue justice affects whether justice is effectively served. So that's a really important point, Margot, to keep in mind. Beth, I want to come to you quickly on sanctions as well. When you and I served in the prior administration, President Biden issued an historic presidential memorandum that changed U.S. sanctions policy to permit the issuance of sanctions on the basis of conflict-related sexual violence alone, rather than in the previous regime considering this crime only in combination with other factors. So that policy change then leads to the first ever imposition of U.S. sanctions based solely on the commission of conflict-related sexual violence. Tell us from your perspective, what is the impact that those U.S. sanctions had, and what are the relative merits of pursuing unilateral sanctions versus multilateral sanctions in practice?
Yeah, this was an incredibly important development, and I was so thrilled to see it. And thank you for your leadership in bringing that about. I think it's created a model that other states can pick up. We're increasingly relying upon states individually to impose sanctions because, as we know, the Security Council, which ordinarily would be the entity within the United Nations that would be imposing multilateral sanctions, is essentially paralyzed because of Russia's willingness to exercise its veto, often with China in tow. So sanctions are a really important tool. I agree completely with Margot. They can't, standing alone, solve these issues, but they should also be deployed as part of a comprehensive approach towards justice and accountability, including the rehabilitation of survivors. Sanctions are meant to be coercive and to change behavior. They're not necessarily meant, at least in theory, to be punitive. But nonetheless, I think of them as accountability tool, especially individualized sanctions that deny individuals the right and the privilege of anonymity. It identifies them as responsible for a particular course of conduct, and it puts real, tangible restrictions on their abilities to operate internationally. They're never going to be completely grounded necessarily, because there's all sorts of ways to engage in sanctions evasion, particularly when the sanctions are not broadly multilateral. Nonetheless, we cannot deny that they have a real impact on the individuals that are subject to those sanctions. Sanctions can take many forms, and they can involve everything from country-wide sanctions, trade restrictions, to restraints on certain industries or commodities. to more individualized asset blocking or to visa cancellations and travel bans. They can be imposed through legislation or through executive action, as we've talked about. They can be unilateral, they can be multilateral via the Security Council, via other multilateral configurations. And we've seen the Europeans really united around a sanctions regime for the situation in Ukraine to reflect Russia's brutal war of aggression. Several notable developments in the way we've thought about and imposed sanctions have really led to significant impacts on women and girls, I think. The first is, as you mentioned, Rachel, the shift away from comprehensive countrywide sanctions towards more individualized, targeted sanctions focused on senior officials who are exercising control over policy, who are, as Margot points out, financially benefiting from a course of conduct, from a campaign of crimes against humanity or other atrocities, and who also exercise control over the leaders of power within a particular country. This shift really addresses the criticisms that were leveled against comprehensive sanctions for the broad humanitarian impact they often had on populations, who, without significantly harming the particular perpetrators, who often found ways to avoid countrywide sanctions regimes, including through their corrupt networks. So, as we know and has been long noted, humanitarian crises are never gender neutral. Sanctions can make it very difficult for women to have access to sexual and reproductive health. They can provoke refugee flows, and we know that the majority of refugees are often women and children. And they can increase gender-based violence within communities where these sort of comprehensive countrywide sanctions have been imposed. As sanctions become more individualized, they do become more increasingly punitive in nature because they're responding to the direct conduct of individuals who stand accused of committing serious international crimes or allowing those crimes to be committed under their watch. And this way, we can reduce some of the humanitarian impact. We've also started to see, as was mentioned, sanctions that are based upon gender-based violence or gender persecution. So, for example, in Iran, we saw individuals and entities who were specifically sanctioned for their role in gender persecution and in imposing gender inequality on women and girls. And these were then expanded during the Biden administration to particularly target the so-called morality police, who'd been deploying violence in response to peaceful protests after the murder of Mahsa Amini. These were then coordinated and with a big splash on International Women's Day with the EU, with the UK, and with Australia. And eventually, over time, they'd been extended to over 70 individuals and entities to mark the anniversary of Amini's death. Sanctions were also issued in Uganda in response to the anti-LGBTQI+ legislation, which made aggravated homosexuality a capital offense and other offenses subject to life imprisonment. And then the Biden administration also used these new powers to issue sanctions against South Sudanese and Islamic State terrorist groups for CRSV crimes. Now, these sanctions are always going to be more powerful when they're multilateral. Otherwise, defendants will become adept at avoiding sanctions in ways that might paradoxically lead to increased levels of corruption. So they're really an important tool, but they need to be deployed alongside a whole range of other tools: documentation, support for NGOs, support for survivors, strengthening accountability institutions, etc.
Beth, I want to pick up on your point at the end there on support for survivors. And Oleksandra, pull you in on that question specifically. Ukraine, we know, has become the first country to provide interim reparations for survivors while conflict is ongoing, which is a really significant step. And we also know at the same time that international aid is shrinking. And your work documenting atrocities in Ukraine could really teach us something about the lessons from this regime. What do you think is the effect of Ukraine's interim reparations regime? And what else do you think is important to obtain meaningful reparative justice for survivors?
I will focus on two important issues. First, it's obvious that survivors of sexual violence, they can't wait when this interim or final reparation mechanism will be built. They need psychological, medical, and financial support immediately. And I remember that just in 1 month after large-scale war started, my organization, in cooperation with others, we made the special memo where survivors of sexual violence can apply for medical assistance, for psychological assistance, for legal assistance, for financial assistance. So civil society initiative united to create such interim ecosystem for survivors of sexual violence and provided a time for state authorities to create it on official level. So this is very important lessons learned, that we can't wait when state officials or politicians will do the right things. We as a people have also a lot of power, much more than we even think about ourselves. And second issue which I want to focus, it's about culture, because not just for survivors of sexual violence, but survivors of other war crimes, there is a necessity to overcome a trauma and to go through this very sometimes long period of healing. And in order to do it more smoothly, it's important to have a trauma-sensitive society, which provides for people safe places where they can go through this healing process. So when I now speak to Ukrainian audience through public events or through media, I used this legal term. We know presumption of innocent, and I transfer it in another way. I start to speak about presumption of care, that we don't know what happened with person who just near us, in shop, in school, in other place. So we have to treat them with care. So this is presumption of care, which has to become a part of our culture, and then it will provide a lot of help for people affected by this war to overcome the trauma.
Oleksandra, I want to pick up on the perspective you just outlined. You've highlighted the importance of a feminist perspective and women's leadership in peace building work. How does women's participation change the prospects for justice and sustainable peace? And what steps do you think are needed to increase women's participation in peace, reconciliation, and post-conflict processes?
It's not just my view, it's data, it's statistic. When women are participated in peaceful process, the chance for sustainable peace is much more higher. So it's proved by history of humankind. So it's better to involve women and to provide them equal access and voice on this political process. And now let's return to our example. We have this peace process, which was started by President Trump to stop this Russian war of aggression against Ukraine. And for sure, people in Ukraine dream about peace. And that's why we are interested in the sustainable and just peace in our country. But what we hear for recent months, we hear about natural minerals, about Russia's territorial claims, about geopolitical interests, even about Putin's vision of our own history, but we don't hear about people. We still have no idea what will be with more than 20,000 Ukrainian children who were separated with their families and illegally deported to Russia, supposed to be adopted by Russian families who will bring them up as Russians. What will be with thousands and thousands illegally detained civilians as men and women, as well as prisoners of the war, subjected to horrible torture and sexual abuse daily? What will be with people in Russian occupation? We speak about millions of people who live in gray zone without any tools how to defend their rights, their freedom, their property, their life, their children, their beloved ones. And Russian occupation is not just changing one state flag to another. Russian occupation means enforced disappearances, torture, rape, denial of your identity, forcible adoption of your own children, filtration camps, and mass graves. So I strongly believe that we need women to be present in this process to raise this human question, because without human dimension, we will never find a path to sustainable peace.
Oleksandra, thank you for your leadership and the work that you're doing under incredibly challenging situations. We're grateful to you for doing it and for sharing your experience with us. Margot, I want to turn to you. You, in our conversation earlier, raised the underrepresentation of women in peace and security processes as one reason why we still see a gap between the accountability framework that Beth outlined earlier and the implementation of that framework. We are now 25 years since the resolution 1325 that insists on women's participation in peace and security processes for all of the reasons Oleksandra described. What do we need to do to make meaningful progress in ensuring women's participation to address this issue, conflict-related sexual violence, and so many others?
This is the missing piece in both respects. No peace for women, even after the guns have fallen silent. That's the experience, historical experience. But also look at the situation as it is today. I mean, shelters are closed down, clinics as well. Medical supplies for rape victims are running out. Peacekeeping missions are drawn down. Women's organizations are defunded. All of this is happening as we speak. This is also the result of the fact that money has been moved from foreign aid to weapons, buying weapons, and to the militarization that goes on in the world and financing wars. I'm moved by what Oleksandra says, and I think we have to rethink everything and start to think long term as well. And as I've said all the time, reparations is what survivors want most, yet receive the least of. They need compensation to rebuild their lives and their livelihoods. And I think also that follow-up is needed, because even when they are awarded money, it rarely happens that this is paid to them. And I also think that we need to communicate the results of effective prosecutions as well. So we need to talk about this, we need to put it on the agenda, but we also have to tell this to politicians at all levels and in governments. You have to make sure that you also pay for this, that you make sure that the resources are there, that you do all of these things. And we know, as exactly as Oleksandra has said already, if women are not around the table, then those peace deals will not last as long as if they were there, because more options will be on the table. Their perspective will be brought to the negotiations or mediation efforts. And when there are peace deals that women are among the signatories, then they will last longer. So that's the experience we have also, and that United Nations have. So we cannot continue to defund all of the things that work to correct these problems, and we have to allow women to sit in this, to be in these negotiations, because so their experiences will never be dealt with. This is a problem. If their voices are not there, do you think the men will raise it? And I think this is also what we know from history, that this is the type of crime that can be commanded, condoned, or condemned. And this is still true, and we have to make sure. I mean, this is why I've introduced my experiences from these years as a special representative on conflict-related sexual violence, all the victims and survivors that we met, all of these discussions that we had with those responsible, with the perpetrators, led me to think that we need a feminist foreign policy that recognizes that men and women should enjoy the same rights and opportunities and obligations in society. And especially when it comes to peace and security, because there cannot be any peace if women are not there fully with their voices being heard as well.
So that framework, as you've highlighted in the past, includes rights, representation, and resources, which is really
yes.
a prescription for action for all of us on this issue. I want to turn now to questions from participants from our audience tuning in today. We have several questions coming in. Our first questioner asks, can you please say more about challenges in collecting evidence and data with respect to war crimes like conflict-related sexual violence? And can you highlight any solutions? Turning first to you, Beth, given your perspective as a prosecutor and your service at the State Department, what do you think are the biggest challenges to documenting the crime of conflict-related sexual violence? And what are some best practices to address these barriers?
Yeah, thanks. It's a terrific question, and something that we've been working on, and through my work in the State Department, was trying to fund new avenues and techniques for documentation. We've seen a big turn to open source investigations. This involves using, for example, things that get posted on social media platforms, things that can be seen by satellites, imagery that can be captured by closed circuit TV, for example, and mined for interesting evidence on the movement of troops, where individuals were based certain places, watching victims potentially be taken into capture, etc. Sometimes conflict-related sexual violence is not picked up by those types of open sources. It often happens in private spaces. And so we're often left with the testimony of individuals who have to have the courage to come forward and have to be presented with an investigatory process that is welcoming to them and that makes them feel safe, secure, and with their dignity intact. So we need to continue to develop these open source resources, and Ukraine has been really at the lead on this in terms of writing a playbook for how to mine all of these open sources. But at the same time, we need to do old-fashioned investigative work, speaking carefully with survivors, creating safe spaces for them to come forward, and then creating trial and investigatory proceedings that make them feel comfortable. So that's going to be one of the key challenges. Often, I think there are a lot of myths about these crimes, that they're impossible, that women will never come forward, that we never have hard evidence, and that is just not true. We need to disabuse ourselves of those myths. If there are systems in place that are active and robust in terms of seeking out that information, there will be evidence. You can have physical evidence, you can find documentary evidence. You often have perpetrators who are posting trophy videos or who are bragging on social media about what they've been engaged in. You often have perpetrators being caught on camera or with clandestine recording devices, ordering or condoning abuses. All of this can be marshaled in order to create an evidentiary record that can lead to a successful prosecution. But we, as sort of the donor community, need to continue to invest in these tools, and in particular, groups working on the ground, like Oleksandra's group, the Center for Civil Liberties, who are really at the forefront of doing this work. We can't do this work remotely. It has to be on the ground with groups that have credibility in those communities, who can collect that evidence to an evidentiary standard that will be accepted by whatever court is able to assert jurisdiction.
Oleksandra, Beth has mentioned Ukraine really being at the forefront of this issue. Can you tell us about some of the obstacles you've seen when it comes to evidence collection in Ukraine, and how have you addressed those barriers?
For current moment, we have a digital tools which provide us an opportunity to restore what happened, to collect evidence, to communicate with people in occupied territories, to identify perpetrators, which we can't even dream 30 years ago during the Balkans War. I think that it's one of reasons why this is the most documented war in human history, but it's not provide the answers what will be next. From the first months of large-scale war, I started to ask to myself, for whom do we document all these crimes for? Who will provide a chance for justice for hundreds and hundreds of thousands of victims of this war? Because the vast majority of crimes which we are documented will be responsibility of national legal enforcement bodies, and it's a huge amount. It's unbelievable burden of responsibility. Even the best national system in the world can't effectively investigate more than 180,000 criminal cases. Ukraine doesn't have the best national system in the world. So this is one challenges. But second, even more frustrating, is that you can't stop these atrocities. We are in the war for 12 years, and I saw how my colleagues with whom we do documentation in first years of the war, they now join to Ukrainian army because it's very frustration when you interviewed survivors of sexual violence or another crimes, and you know that in the same second, the same horror is going on with other people in more than 143 legal places of detention, which you identified, and you have no legal tools how to stop it. This situation, when you find yourself in circumstances when the law doesn't work, it's very frustrating. And that's why I'm still there, because I believe that we have to restore legal order. I believe that the law doesn't work, but it's temporary, that with all our efforts, we'll manage to bring justice.
I want to turn to our second questioner, who observes that conflict-related sexual violence is not only a women's issue, it's a human rights issue. And we know that it affects women and girls and men and boys, people of all genders. How can we better involve men and boys as champions to help increase accountability for conflict-related sexual violence? Margot, why don't we start with you in response to our questioner?
Well, we have to talk about it, we have to write about it, we have to put it on, on the political agenda so that it becomes clear that this is a matter of peace and security. It concerns everybody. And I think also, going back to the last question, because it's really about the to-do list, it's a rather long one, but I think that I want to add to that, because my list was, to enhance documentation and evidence collection. We've already talked about that. We need to do it in the kind of with standardized protocols that survivors have been involved in designing. We need to have secure and ethical data practices. We have to bolster the local capacity to bring it down to a level where local police and all those involved can understand exactly what is in front of them. And also to have this survivor-centered support and reparations. And this is also where men and boys need to be engaged. And I think one of the most touching things that I experienced also as special representative was when we went to the DRC and we met in one of these salles d'écoute, where they could give legal advice to rape victims. And this young girl came, and it was her father who had brought her there. And that was very unusual, that the father came with her and supported her all the way. And this was also, suddenly he realized that sort of the future, not only her future as an individual, but the family, the whole village, because she was like a star in her school and what have you. And that it was their future embedded, of course, in her. And when this was done to her, it fully hit him as well, that this cannot be, and I have to give her all my support. And this is what we have to understand, the whole community, that this is what happens. It happens to not only an individual and a family and a village, but to a country and to peace and security in the end. And this is the arguments we have to use also with men and boys. And of course, to understand that they are also survivors of sexual violence. And this is what we've learned, of course, through dealing with all of these cases. But I think we have to make it very tangible, very practical as well, because this is the reality right now, as Oleksandra has described in Ukraine and everywhere else. It's sort of the lack of resources, the lack of support, the lack of help and assistance to deal with this massive war crime that is being perpetrated, and we just have to continue to do it. And I think we should recognize all the progress made, the fact that we have a legal system and mechanisms that we can use, but we also have to make sure that it is properly used and that there is a whole chain and that the survivors are at the center of this.
So with that admonition, Margot, where we certainly want to recognize the progress that has been made on this issue that's been illustrated in the discussion today, while recognizing the gaps that still exist, I want to close with a final question for each of you. What do you think is the most important step? What is the takeaway that you want our listeners today to focus on with respect to what individual nations and our community of nations can do to increase accountability for conflict-related sexual violence going forward? A closing word from each of you. Beth, why don't we start with you?
Sure. I'll just mention the issue of resources, which has been a theme that has run throughout our conversation this morning. Historically, governments have often put money towards this work, either by funding non-governmental organizations or strengthening their own internal systems to be able to do these investigations and contribute evidence to accountability mechanisms. We are seeing a retreat in that, as Margot mentioned, and the Trump administration is in the lead, really, by turning off and then trying to rescind millions and millions of dollars in funding, some of which was dedicated to ensuring accountability for conflict-related sexual violence and helping to rehabilitate victims. I know many of the resources of my office have been turned off that we had been funding and projects and work that we had been funding. So the rest of the globe is going to have to step up and fill that gap. And I'm really hopeful that philanthropists, large and small, and ordinary people will step in to support the work that NGOs and others are doing so that we can get back to the point where we can rebuild the kind of international infrastructure that the donor community had previously invested in.
Oleksandra, a final word on what is the most important step at this moment.
Two things I want to mention. I worked with people affected by this war directly, among them survivors of sexual violence. We have to look to these people not just as survivors, but as fighters for justice, because they really are. And the most appropriate and effective changes which was done in Ukraine, it was because of their efforts, and we have to acknowledge this. And second, I think in order to decrease the level of conflict-related sexual violence during the wars, we have to do something in peaceful time and to create a zero tolerance to sexual violence at all, started with domestic violence. And we need to do something with our culture, and this will have the long-term impact, even if society will face as such external or internal challenge as a war.
Margot, a final word. What do you want our listeners today to focus on going forward?
Well, I could make it very easy for myself and say that I agree with what both Beth and Oleksandra said, and I repeat that we need that full understanding and to devote resources to this, to have national action plans that also show that you are serious about it, to mobilize the political will to deal with this problem. And I always say that if we want to change the society as it looks now, very, very worrisome, with so many wars going on, we have to start to look at what do we want for our children? What do we want for them? Can't we start thinking more long term? Is this the world that we want to hand over to children and grandchildren? And if we reflect on that, we know that what is good for children is good for us as well. And bring out some money from the militarization to actually solve this problem or help to release some of the pain from this awful scourge that is conflict-related sexual violence and rape, and Slava Ukraini as well.
Well, while our discussion today confirms that there is significant work ahead to increase accountability for conflict-related sexual violence, our panelists today have really helped illuminate the path forward. So I hope you will join me in thanking each of them for sharing their time and expertise with us. And now I'd like to turn to Jean-Marie Guénaud, the Arnold Saltzman Professor of Practice in International Public Affairs and the Director of SIPA's Kent Global Leadership Program on Conflict Resolution, for closing remarks. Jean-Marie, the floor is yours.
Well, I'm really pleased to partner with the Institute of Global Politics for this important event. When I listen to the compelling speakers we just heard, I just have two thoughts. The first is I reflect on where we were when I became an actor in the fight against conflict-related sexual violence 25 years ago, and where we are now. And indeed, there's been a number of progress that were highlighted by the speakers. There's been more training. The legal framework is much better. I mean, there is, and this conversation actually, I don't think it would have been possible 25 years ago. It certainly would not have had the depth of thinking that we have had. So there has been progress. And at the same time, I see that we are moving backward at the moment, let's be honest. We are moving backward. And so we have to reflect, and that's the other point I want to make. We have to reflect on how we can do better. And I think, for accountability to happen, there has to be a demand for accountability, a demand of society for accountability. And there I could not agree more with what Oleksandra Matviichuk just said. I think conflict, in a way, always amplifies the ills of a society. It amplifies what is wrong in a society. And so the fight against conflict-related violence, it starts in times of peace. It starts with a transformation of our societies in peace. That's what is needed if we want to do better, if we want to make sure that instead of attacking the International Criminal Court, we support it. Instead of looking the other way when there is sexual violence in time of peace, we prosecute it so that when war comes, we are stronger and we are prepared for that. So that's my thought. That's my concluding thought after this important panel. And I do hope that the meeting we just had will help raise the awareness for in our societies, which are lucky enough to be at peace and not in the middle of a horrible war like Ukraine or Gaza or Sudan. In our peaceful societies, we need to think more about what it means to have sexual violence.